Okay, good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Okay, let me go ahead and introduce the other members of the panel for today. We have Judge Sasso and also Judge Jessica Rexedler. We're happy to have her join us, sitting as an associate judge from the 18th Circuit. These oral arguments are being both recorded and being played live, so the public can watch it on YouTube. They're being streamed live. Each side will have 20 minutes for oral argument. Mr. Greenlee, how much time do you wish to divide or save for rebuttal?
Your Honor, I'd like to preserve 5 minutes for rebuttal, if I might.
Okay, I'll try to help you in that regard, but you should have a clock on the screen, so.
Yes, I see it. Thank you.
Okay, all right, you may proceed.
Good morning or good afternoon, Your Honors, and may it please the court. My name is Andrew Greenlee, and along with my co-counsel, Anthony Lejean, we represent the borrowers in this foreclosure appeal. Your Honor, this case turns on the applicability of the Judicial Estoppel Doctrine. If Judicial Estoppel is inapplicable, then we should win. If Judicial Estoppel applies, then we should lose. We think Judicial Estoppel is inapplicable for at least 3 reasons. First, Judicial Estoppel does not apply because the plaintiff, U.S. Bank, engaged in post-bankruptcy misconduct. Specifically, U.S. Bank made a material misrepresentation in a motion to substitute itself as a party plaintiff. In that motion, which again was filed after the bankruptcy had concluded, U.S. Bank claimed that it became the trustee on July 2nd, 2012. Now that date is very important because the suit was filed in June of 2012. So the plaintiff represented that the loan changed hands after the commencement of the suit. This was false. As the borrowers learned through the course of discovery, the original plaintiff, Bank of America, transferred the loan to U.S. Bank some 2 years before the foreclosure commenced. In other words, Bank of America had nothing to do, it had no connection to the lawsuit on the date that it filed the suit. If U.S. Bank had told the truth in this motion to substitute party plaintiff, it would have been admitting that the original plaintiff, Bank of America, lacked standing at the outset. So U.S. Bank affirmatively misrepresented a material fact in order to avoid dismissal.
Was that issue raised in the context of the motion to substitute?
It was not raised in the motion to substitute, but it was raised in a subsequent motion for summary judgment that was filed by the borrowers.
Okay, and was the summary judgment, well, let me ask it this way, was that specifically raised as a defense to the estoppel in the context of the proceeding?
Yes, Your Honor. At the trial court level, the borrowers made the very same argument that we're pressing in this court, and that is that you can't engage in fraud upon the court. And this is, interestingly, that the bankruptcy court in Orlando, the very same court that the borrowers received their discharge from, said in In re Ayala that judicial estoppel should, quote, not be viewed as carte blanche for post-bankruptcy lender misconduct. So we think that if the judicial estoppel argument had been raised in the bankruptcy court, we know what they would have said. They would have said, look, you can litigate, and if you can prove that there's fraud upon the court and post-bankruptcy misconduct, then we're not going to have judicial estoppel be a bar from you to defend the case on the merits.
And did the borrowers obtain a ruling on the misconduct issue?
I think the court denied their motion for summary judgment on that point. Mm-hmm. But they did obtain a ruling insofar as when the case proceeded to the trial, there was an evidentiary hearing on the applicability of judicial estoppel.
Right. And
the court essentially said at the conclusion of the evidentiary hearing that the borrowers would not be allowed to defend on the merits. So the court,
right, and I'm recalling in the record, that they would not be allowed to defend on the merits, but I'm not recalling specifically, and I can look back through it, a portion of the record where in the evidentiary hearing and in the ruling on the judicial estoppel matter at the trial, that the court issued any sort of ruling on misconduct defense, essentially, to estoppel.
Right. I don't think there was any affirmative finding one way or the other.
So then would that issue be waived for the purposes of appeal by virtue of the fact that the borrowers did not obtain a ruling on misconduct as a defense to estoppel?
Well, I think that it would be, it would have had to have been denied in order for the case to, but by denying the borrower's argument and saying, borrowers, you cannot defend this case on the merits, that's, I think, either tantamount or the essentially the equivalent of a ruling that you didn't prove your case of fraud upon the court. So I think that is.
Well, you would agree that that's a factual issue.
Fraud upon the court is a factual issue. That's right, and there was an evidentiary hearing that was undertaken on that point, and I think that argument was implicitly denied. It had to have been denied because the borrowers were not allowed to defend the case on the merits. Okay. Otherwise, the borrowers, had they prevailed on that, we think that they should have been allowed to defend the case on the merits.
There was no actual findings of fact made, though, as to fraud upon the court, and no rehearing to request those findings or anything along those lines. So correct? That's
correct, but I think it was adequately preserved on appeal. If Your Honor, no, again, we think that the record is such that this court can make a ruling on this on appeal. If Your Honor disagrees, then the proper approach would not be to affirm the foreclosure judgment. It would be to remand to the trial court to allow us to obtain a finding. Again, we did everything we could to obtain a finding on this. We moved for summary judgment on it. That was denied. We also raised it and made the exact same argument I'm making here, and that was implicitly denied by the trial court when it said, borrowers, you're not allowed to defend this case on the merits. So,
well,
I mean,
moving to what the court did rule on, would you agree that the court essentially ruled that the party to whom the debtors surrendered the real property to in the context of the bankruptcy proceeding was the plaintiff in this action?
I don't believe that there was any express ruling on that point. I think my recollection of the ruling was that it was they summarily ruled that the borrowers would not be allowed to defend the action on the merits.
Well, the court did make factual findings in advance of that legal conclusion, correct?
Well, if the court did make a factual finding on that point, we don't believe there was competent substantial evidence.
Okay, so could you flesh that out then? Why is there not competent substantial evidence to support the trial court's factual finding that ASC was the servicing entity for Wells Fargo, which was servicing entity for Bank of America, and then changed by virtue to Bank of America as trustee?
I think that the link in that chain, and this is in the trial transcript at page 28 through 29, the bank attempted to elicit testimony that ASC was a division of Wells Fargo. But that testimony was never actually, it was objected to, and the objection was sustained based on improper foundation. The witness was asked, and this is on page 30, whether she knew the relationship between ASC and Wells Fargo, and she said, quote, I do, but then trial counsel never made a follow-up question to really elicit the key point, which was, well, I don't know what the key point was because there was no testimony other than that she knew that the relationship between ASC, that there was a relationship between ASC and Wells Fargo. So again, ASC was the party to the bankruptcy proceedings, and it was not a party to the proceedings in the trial court. And it was the burden of the bank to establish the elements of judicial estoppel, and we don't believe that they established the elements of judicial estoppel here. And again, that's number one, because they didn't establish that it was the same party or.
Would you agree that a successor? Oh, sorry, go ahead, Judge.
I'm sorry, I was just going to say, but if you're indicating though that even if it was ASC who had the property at the time, you're not disputing the fact that the property was surrendered in bankruptcy court. So again, I believe Judge Sasso was going to ask the same question. The successor in interest would then have the right to exercise the judicial estoppel. So are you indicating there was no surrender of the property in bankruptcy court?
No, we admit that there was a surrender of the property in bankruptcy court. And in fact, Mr. El Hadiri, during the evidentiary hearing, he testified that, hey, look, if it had been ASC that it was bringing the foreclosure action, we would have surrendered the the property in the foreclosure court. So there was, again, we don't think that that the borrowers were litigating in bad faith. And also, again, this is crucial, the lender has to establish the elements of judicial estoppel in order for the court to apply that. And we don't think that there was competent substantial evidence to support the notion that ASC was a division of Wells Fargo, which was a servicer. We don't think that there was competent substantial evidence on that point. And for that reason, we think that judicial estoppel was inapplicable. But even if we're wrong about that, we don't think that the borrowers took a, quote, took a completely inconsistent claim, or took a clearly conflicting position in a subsequent action in judicial proceeding. The borrowers I'm sorry.
And I'm sorry to interrupt. What wasn't ASC though listed on the statement of intention that from the bankruptcy court as a servicer for Wells Fargo? So wasn't that established through there that there was a relationship between ASC and Wells Fargo?
Well, even if that is probably true, if you're asking me that question, I'm going to take for granted for the purposes of this that's true. I don't have it in front of me, but even if that is true, the party plaintiff was not Wells Fargo. The party plaintiff was U.S. Bank. So that's who the foreclosure judgment was entered in favor of. So I'm not sure even if that is the case, I'm not sure that that's enough to establish that they were the same party in the proceedings. And even if it were enough, there was no articulation at all as to the prejudice that U.S. Bank suffered as required to be entitled to invoke the judicial estoppel doctrine. So without saying we were prejudiced by X, Y, and Z, we don't think that they carried their burden. But having said that, again, we think if you look at the purpose of the judicial estoppel doctrine, it's to preserve the integrity of the judicial proceedings, right? You can't make a mockery of the court by claiming in one forum one thing and then completely changing your position in another forum. And it's an equitable doctrine. But we think that by engaging in misconduct themselves, that they forfeited their right to invoke this equitable doctrine. And we think that we should have been allowed to defend the case on the merits.
How is it that your client, though, isn't doing something in one forum and then doing something in another forum by claiming that they'll surrender the property in one forum, but then in the foreclosure action, trying to claim judicial estoppel and not allowing the surrender and the turnover of the property?
Well, our position in the trial court was that Bank of America was the improper party at the outset of the litigation. So to the extent that we took a position in the bankruptcy court, we said we will surrender the property to a party who's legally entitled to foreclose on it. So if U.S. Bank, by virtue of the fact that Bank of America was the original party plaintiff, if U.S. Bank was not legally entitled to foreclose on the property, then it's not a completely inconsistent.
That's not what the surrender though was. The surrender was to ASC without any sort of conditions or qualifications.
I'm sorry, Your Honor.
Go ahead.
Well, I just want to stress that we don't dispute that in the bankruptcy, in the bankruptcy, our statement of intentions, the borrower said, we agreed to surrender the party to ASC. We don't dispute that, nor could we. So I don't want to make it seem like as if there's any lack of clarity on that particular point.
Let me ask you this way: would you agree that there's a difference between determining a successor in interest for the purpose of the application of judicial estoppel and determining who is legally entitled to enforce a negotiable instrument pursuant to statute? Those are different legal analysis.
I think that's right. I think that's right. A successor in interest. Well, if I could answer it this way, you can be a successor in interest and you can not be entitled to enforce a negotiable instrument, but you can be a successor in interest, pardon me, and be entitled to invoke judicial estoppel. But again,
right. So simply because, in other words, if it was surrendered to ASC, it's not necessary to the surrender that ASC ultimately have standing pursuant to statute to foreclose on the loan. That's a separate legal issue.
It's a separate legal issue. Yes, Your Honor. But we do believe, though, that in the absence of any prejudice, we don't think that there can be any judicial estoppel. And they simply failed to even argue the point or advance any prejudice that they had sustained. They do on appeal, to be fair. They do talk about how they're prejudiced on appeal. But again, we don't think that that was an argument that was made in the trial court, and that was part of their burden. That was one of the elements of judicial estoppel. And so we think for that reason, even if it is true that it is the mutuality of the parties is present, we still think that they failed to carry their burden of establishing judicial estoppel and their entitlement to that we be estopped from defending the case on the merits. And I think it's important to stress that if this were a normal foreclosure case, we would have won without any question. I mean, again, they admitted that they didn't have, that they held the note on the date the action commenced. They admitted that they were not the owner of the loan. And so there was no other alternative theory of standing that was even advanced. So in the absence of judicial estoppel, we win going away, and it's not even a close case. So that's important to bear in mind here. So you would have to overlook their patent lack of entitlement to foreclose on the property in order to affirm the judgment. And we think that that's just it's not right, particularly in light of the fact that they engaged in this misconduct, that they misrepresented their status to the trial court on not just any point, but on really the crucial element in the foreclosure proceedings. That is that they were entitled to foreclose at the outset of the case. So
you're down to about 4 minutes and 20 seconds.
Your Honor, I'd like to reserve the remainder of my time.
All right, thank you. All right, Ms. Wilson.
Good morning, Your Honors. I'm here, Brandy Wilson, for the plaintiff appellee in this action. If the panel doesn't have any preliminary questions, I'll begin with my response.
You may proceed.
The subject loan has been in default for 9.5 years. In this case, we have defendants who have admitted to filing bankruptcy, defendants who have admitted to surrendering the subject property, albeit they seem to argue that there shouldn't be ramifications to the surrender. We also have defendants
What's in the record about the relationship between Wells Fargo and your client?
Your Honor, not to mention my witness testifying that there was the relationship between the two. The defendant, Mr. El-Hadiri, came onto the stand and I questioned him about his loss mitigation efforts, and he talked about going to conventions with Wells Fargo in order to get a loan modification, and that the result of that, he said, was his ASC modification. The borrower seemed well aware of the relationship between the two as well. And Your Honor, we have the defendants admitted in pages 4 to 5 of their brief that they wouldn't be contesting the foreclosure action at all had ASC been the plaintiff in the foreclosure action. Here we have plaintiff who filed a verified complaint in 2012 stating that it had the right to enforce the loan documents. Attached to that complaint was a copy of the note, stamped true and correct copy with a blank endorsement, the recorded mortgage, the 2 loan modifications. The 2 loan modifications from ASC have the same loan number listed as the surrender loan number to ASC on the bankruptcy petition. And then plaintiff then came to trial in November of 2019 with that original note, the original mortgage, and the 2 original recorded mods with those loan numbers. And they were in the same condition substantially as what was attached to the complaint. The only difference being that true and correct copy stamp, which the lower court judge had said did not change the Ortiz presumption. In addition, the defendants hadn't raised any arguments to destroy the Ortiz presumption. Defendants do not seem to be objecting to a surrender of the property. They only seem to be objecting to a surrender to this particular entity because of a perceived fraud, a fraud that they have failed to plead or actually prove. Arguments that the defendant have admitted that they raised as well as they could in the summary judgment filed December 21st, 2018. That denial of that summary judgment has not been appealed. Here is not part of this appeal. They brought no new evidence at the trial as to any sort of alleged fraud issue. The entire fraud argument that they have is predicated on a mistaken belief that Bank of America, as trustee for the 2006-6AR trust, is an entirely different entity than U.S. Bank as trustee for the 2006-6AR trust, rather than the fact that the plaintiff the entire time since this action was filed in 2012 was the trust, Morgan Stanley Trust 2006-6AR. Let me get here. Let me get my notes here.
Do you have any case law that indicates that the party itself, the trust, because I was trying to see in your brief, the party itself, the trust, would be the appropriate plaintiff, and that the fact that the trustee is indicated and has to be substituted, where you actually have to go file a motion for substitution of party to substitute one trustee for the other, to indicate that that is not an party to the suit?
Your Honor, I actually did look for case law on this, and if I missed it, I apologize, but I was unable to find any in either direction. The argument that was raised at the summary judgment in the trial by defendant is that they are separate entities, and the judge correctly asked the question in the lower court, hold on, was the loan sold to a different entity, or is the trustee just updated? And it was the trustee is just updated.
And I think the case law is pretty clear that the trustee holds legal title to the property. Was there competent substantial evidence of the substitution of the trustee or the transfer of the trustee, whatever the correct language is?
Yes, Your Honor. Attached to the motion for summary judgment were the documents showing in the system where the trustee had been updated. And while there was testimony in the briefs about a 2010 transfer, the documents that were attached to plaintiff's motion to substitute, which motion also detailed that it was simply a trustee update. It did show that on July 2nd of 2012, plaintiff's system was updated to reflect the updated trustee, and the power of attorneys reflect that as well, that were entered into evidence.
And I noted that in the system, you had said the client's system were updated, but then you had the testimony from the other individuals and the corporate representatives that indicated it was 2010, where the substantially all of the corporate documents and corporate trusts were transferred from Bank of America to U.S. Bank. So what do the actual documents themselves say, other than the system being updated or an input being done?
Well, Your Honor, that's the confusing part, because it all depends on what date you consider the transfer, the date the agreement was made, the date that an assignment of mortgage was effectuated, the date a power of attorney becomes active, or the date that it finally gets to update it in a system to where a plaintiff can actually request the substitution. So in this case, there appears to be from the representative, Ms. Johnson from Wells Fargo, as to the 2010 trustee update. And that's the date that it appears that the trustee switched from Bank of America to U.S. Bank. And then the 2012 dates are when finally the documentation caught up to it. All that corporate documentation, the assignments, and the power of attorneys finally caught up and got recorded.
And when you're referring to the documentation being updated, you're referring to the documents being boarded through the system?
No, because
the boarding process, or is that different?
No, that's completely different, because the boarding process has to do with the servicer.
Okay.
With the trustee, there's not the boarding process. It's mainly just updating the trustee.
All right.
What is your response to appellant's argument that the finding of essentially successor in interest was not supported by competent substantial evidence based on that kind of equivocal testimony as to the known relationship between ASC and Wells Fargo?
Okay, so you're not talking about the trustee successor in interest, thus
No. Well, now the relationship between ASC and Wells Fargo is, I think that's a separate issue.
Well, Your Honor, I think that the plaintiff's witness testimony testifying that there's a relationship, that it's a servicing arm, the fact that it is common knowledge among the industry, and also Mr. El-Hadiri's own testimony that they willingly entered, because let me clarify, he didn't sign the mod, but he spoke on behalf of his wife as they, that they entered into the modification with ASC pursuant to their Wells Fargo meetings. So that issue, while I do have merger documents, when a borrower admits on a stand that they know of their relationship, there doesn't seem to be a reason to show that to the court as they're admitting to knowing the causal link. I've got most of my argument in. I don't know if the panel has any further questions on it.
Any other questions?
I guess if you could also just briefly address the appellant's argument regarding prejudice and the application of judicial estoppel.
Oh, yes, absolutely, Your Honor. So the bankruptcy cases here for the judicial estoppel, first off, the Ayala case that was mentioned by defendant is a very specific situation. The bank in that case continued to accept payments after the bankruptcy surrender. The loan wasn't in default when they surrendered the property. They kept making payments and the bank kept accepting them. And then when the loan went into default, the bank tried to force the surrender then. That's not the situation here. In the instant case, plaintiff filed their foreclosure action under the trust name. After that was filed, the borrower filed their filed their bankruptcy. But borrowers, despite knowing there was a foreclosure action listing the trust, listed ASC as the entity to surrender to. They did this during the action, and then no payments were made at any point in time since the foreclosure has been filed. So defendant is trying to use the Ayala case to say that that the acceptance of payments is misbehavior, and that it is equal to plaintiff's alleged fraud with the trustee names. It's not the same issue, Your Honor. The argument is only defendant trying to choose the creditor in which they're surrendering the property to. And it's not really how it works. Plaintiff has shown the entitlement to enforce. Under the Lewis v. Enova case, the courts have applied judicial estoppel when there is that unequivocal surrender. I think the prejudice is pretty obvious. This complaint was filed in 2012. We went to an 8.5-hour trial in the end of 2019. I mean, there's 7.5 years of interest, of attorney's fees, of property preservation, escrow advances. The property is severely underwater at this point. So I think that the prejudice is pretty clear that by not sticking to their surrender after the bankruptcy discharge has cost several years of fees and advancements that have occurred. Well, they didn't see. And in the N. Ray Elowitz case, because N. Ray El-Kubi was mentioned quite frequently in the initial brief about a surrender to a trustee, but the N. Ray Elowitz case out of the Southern Bankruptcy Court in 2016 said that the surrender should be to the party entitled to enforce. And in that case, the party entitled to enforce is the party under 673.3011, which under this case is plaintiff who had possession at the time the complaint was filed and at the time of trial with possession of the blank endorsed note, regardless of who defendant stated that they were surrendering the property to. And then there was recently also the Sales v. Nation Star case out of the Fourth in 2018. In that case, it's actually very similar to this one because Nation Star was not we are the same plaintiff the whole time, but Nation Star was a substituted plaintiff in that action, but they were still able to apply judicial estoppel in that action, even though the borrowers surrendered their property to another entity in the bankruptcy. The court still struck the defenses and held that judicial estoppel applied. So I believe that the same thing should be applied here. And unless the court has any other questions, I surrender the rest of my time.
Yeah, thank you. Mr. Greenlee, rebuttal.
Thank you, Your Honors. Quickly, I have 5 points to make. First, regarding the Ortiz presumption, it's plainly inapplicable because the witness at trial testified that Bank of America, she admitted that Bank of America was not the holder of the note at the time the action commenced, and that's at page 211 of the trial transcript. So they can't rely on the Ortiz presumption because that's applicable when the plaintiff is the holder of the note at the commencement. And so they admitted through their own witness that they did not hold the note on the date the action commenced. It was U.S. Bank who held the note on the date the action commenced. Second, even if Wells Fargo, even if they did go to a convention and they knew that it was Wells Fargo is not equivalent to U.S. Bank. So that's another point. Third, regarding this concept that Bank of America is the same entity as a trustee and it's just the trust that matters, there is case law on that point. It's cited in our reply brief, the Conley case. And that was the reasoning of the Conley case, was that you couldn't prove that one trustee had a connection to the other trustee. So it's Bank of America, the plaintiff is Bank of America as trustee on behalf of the trust. So the party plaintiff is Bank of America. That's a crucial point here. So that was the initial party plaintiff. The second party plaintiff was U.S. Bank as trustee on behalf of, and then it's a long case name. So again, if they didn't think that it was important, that the identity of the trustee, they wouldn't have moved to substitute as party plaintiff a different trustee. Third, this case is not your typical case that your typical judicial estoppel case, because there is a strong showing that of misconduct on the part of the lender. And I want to be very clear on this point. U.S. Bank, Ms. Tanya Johnson, she sat for a deposition, and in her errata, so she got together with the attorneys, and in her errata sheet, she said, and I'm reading from it now, on November 11th, 2010, U.S. Bank acquired substantially all of Bank of America's corporate trust business, acquired assets, which this loan was a part of. So their own witness testified that Bank of America had no interest in the loan whatsoever. And it's shocking to me that my friend on the other side would continue to say that the operative date was 2012, when in fact it's their own corporate witness, U.S. Bank's own corporate witness, Tanya Johnson, admitted that, and this is again in the errata after looking at her deposition testimony, and it says upon additional review of the business records. So she took another look and said, you know what, that's not right. It was November of 2011 or 2010, pardon me, when the assets changed hands. So, I mean, I don't know how much clearer it could get. The Bank of America had no connection to the case when when the case commenced, yet it was Bank of America who was bringing suit. U.S. Bank tried to cover up that fact by claiming in trial court, and frankly in here, that the operative date was in July of 2012. And that's important because the case was filed in June of 2012. So again, that's the most critical element in the foreclosure case typically, is standing at the commencement of the suit. And they misrepresented the date, and that was after the bankruptcy. So we think that they forfeited their right to invoke judicial estoppel because they themselves committed fraud upon the court when they attempted to substitute the party plaintiff. And again, you can't just come into court and say, invoke this equitable doctrine when you yourself have unclean hands, have misrepresented the critical fact that would have precluded your entitlement to a foreclosure in a motion before the court and prevailed on that motion. And Your Honors, if there's no further questions, we would ask the court to reverse the case and remand for further proceedings, specifically for an involuntary dismissal in the trial court, Your Honors. Thank you.
All right, thank you both. We'll be in recess until our next oral argument at 2:30. Thank you.